Unfortunately, your choice of language was such that the camera operator here can't take a picture of it.
What's going on, y'all? This is Brandon, aka the Port City Attorney. Today, we're going to be reacting to a clip from Judge Judy. Let's get after it.
All parties in the matter of Sonkrant Nichols, step forward.
21-year-old Megan Sonkrant is suing her ex-boyfriend, 24-year-old Tyler Nichols, for loans to buy bedroom furniture and matching tattoos.
Miss Sonkrant, this used to be your boyfriend. It's not your boyfriend anymore. While he was your boyfriend, the two of you went on holiday together, decided to get matching tattoos. He didn't have any money. You laid out the money for his tattoo.
Yes.
Sometime way after that, he used your credit card to purchase furniture. So there was a loan for furniture for his apartment.
Yes.
He still hadn't paid you for the tattoo, right?
Correct.
Forget about the tattoo. Do you still have the tattoo?
Yes.
Do you still have the tattoo?
Yes, but it's covered.
But what?
It's covered.
It's covered with what?
Writing.
What did it say?
It was a K with the heart, like a king.
It's what?
K with the heart.
K with
Oh,
the
with
heart.
a K with a heart. Is that?
All right, so first off, this is like basically a small claims proceeding, right? So what Judge Judy is trying to decide is whether or not what was given to that man constituted a loan or constituted a gift. A loan typically has to have offer and acceptance and some sort of monetary value given, right? The question here is going to be whether or not she paid for the tattoo out of, some sort of a gift, good nature, goodwill to her boyfriend at the time, or whether or not there was an actual contract for a loan.
Is that your name?
No, it was king and then mine was queen.
I really have to.
Classic boyfriend-girlfriend tattoos, king and queen. Maybe just wait till you're married. Even then, maybe wait a little bit, a little bit longer.
Get my hearing checked. Swear. Everybody better go to articulation classes.
That's not going to happen.
Okay, now, you moved into an apartment, you didn't have any furniture.
Correct.
And how did you get furniture?
Miss Sonkrant offered to get
What
out
did she
furniture
say?
for me. She knew that I didn't have any furniture, so we went to the furniture store, and she helped me pick it out, basically.
So this is where he's starting to infer that, hey, this was a gift. I don't have to pay this back. She was just doing this because we were romantically involved and it was out of her goodwill and good nature.
Okay, great. And do you remember how much it was?
Not off the top of my head, no.
But you were making payments on it.
Not really.
You never made any payments on it?
No.
Never?
No.
Really? When was it purchased? In what month?
I would say September-ish, yeah.
And
Not making payments would indicate that it wasn't actually not a loan, right? So it was not a loan because I wasn't making payments on it. That would be the argument that I would be making if I was in that position.
it was bought on credit?
Yes.
How much was it?
It was $2,235.54.
Well, what kind of work were you doing, Mr. Nichols?
Worked in a factory. I was a machine operator.
Still there?
No.
What are you doing now?
Right now, I'm currently looking for a job.
So you don't have a job?
No.
And what kind of furniture did she buy you?
It was a Serta mattress, king size, and the bed frame, and the TV.
And you have a new girlfriend?
Yes.
Do you watch the TV with your new girlfriend?
Yes.
And you sleep on the mattress and the frame?
Yes.
You think it's right that the plaintiff pay for that?
I mean, it was a gift.
Bingo! I haven't watched this before. I just assumed that that was going to be the argument, and that's the argument that he should be making if he was in that position. Now, on the flip side, the ex-girlfriend should be making the argument of, no, this was a loan. I never intended for you to have this scot-free. It was not a gift. That's the argument she's essentially making by bringing this claim against him.
Might have been. I'm just asking you if you think it's right that she pay for it.
Me and him were together when she
I didn't
bought
ask.
the bed.
I didn't ask you a question.
Another tip, or a tip rather, if you're in the courtroom as a witness, don't just start talking. I know this is a TV show, it's dramatized. I can't say that word very well, but just don't talk unless you're being called upon. It might make life a little bit easier for you.
Okay.
Do you think it's right that she pay for it?
Yeah, I should pay for it. No, I don't think it's...
Bird, that one's irritating me. Would you get it ready?
Sure. Man.
So the judge does have the authority to remove folks from the courtroom if they're being disruptive, in any sort of way. And so she had, spoken up, interrupted, and then laughed at a response. So Judge Judy, in an actual courtroom setting, has the authority to have someone removed, even held in contempt of court.
Over this way.
You don't have to bring your new girlfriend. It's annoying. Do you understand?
Yes.
Just annoying. Now, Miss Sonkrant,
Yes.
when did you and Mr. Nichols break up?
In the beginning of December.
When was the first payment due on the furniture?
What would have been September? October 24th.
Who made that payment?
He made that payment.
Show me.
I only have the bills. I don't have it showing that he paid, but I have evidence of him saying that he was paying me.
I would like to see that.
All these.
Isn't it nice I got rid of
Now, typically in a normal courtroom setting, the evidence that she's going to be showing to the judge has to be provided to the defendant first, and then the defendant then gets an opportunity to object as to the entry of the evidence. You have to lay some sort of foundation. There has to be foundation for that to be laid. There's a couple ways that you could do it. If it's a text message, right? You know, this is a number that I regularly texted him at. This is how I communicated with him. I know it was him. Although, two things, this is small claims court, presumably, and there's really not a whole lot of rules of evidence when it comes to small claims court, depending on what jurisdiction you're in. And two, this is Judge Judy.
the new girlfriend? Just in case you think I'm going to be exceedingly hard on him. I just want you to read some of these emails back and forth.
Okay.
And I want you to tell me whether, based upon these emails, you would buy U.S. savings bonds.
Do they still sell those?
If you have confidence in the country. You told her you were going to pay her for the furniture. Unfortunately, your choice of language was such that the camera operator here can't take a picture of it because you only know how to express yourself using four-letter expletives.
I like that. I've actually been in a situation where a witness was reading off text messages and the judge said, just stop. These are too vulgar, too obscene. Let me just read them. This kind of stuff actually does happen in court.
I don't believe.
You don't believe what?
Where did I say that I paid her? I told her.
See, this is why you have to present the evidence to the defendant before you offer it to the court, and the court makes some sort of an inference off of that. He hasn't been presented that. He's not getting a fair shake.
I was going to pay for it.
Would you show Shakespeare, please, the emails?
Honestly, I want to read them. Just turn the camera. Maybe this should be a YouTube show so you don't have to be beholden to the rules of daytime TV. But everyone loves Judge Judy when they're sick.
In the emails is where you told her.
Yeah, man.
Now you see where you told her you were going to pay her?
Yes, I remember those conversations.
Good.
Dang. So he didn't really have a good argument. You know, I like to take the hard argument. Obviously, he was going to have to pay her back because they were dating. They weren't married. It wasn't marital property. They weren't together very long. He was always going to have to pay her back. But it's fun to make the argument on the other side. Maybe you should try it every once in a while. Play devil's advocate.
$2,235. Judgment for the plaintiff. Good done.
That was Judge Judy. She is a staple in the daytime TV community. Now, all of these shows are drama. They typically are fake actors. I don't know if Judge Judy has actual actors or if they're actual situations. But in a situation like this, if you're ever going to small claims court, here's a couple things that you should know. Number one, you need to bring evidence. So bring multiple copies of whatever you are purporting to be evidence. So if you're going to be offering text messages, right, have 3 copies, one for you, one for the court, and one for the defendant. That way, everybody can be looking at the same thing at the same time and everyone's on the same page. 2, label those articles of evidence so that it's easily presentable to the court. Again, you want to make sure that you have 3 copies, but make sure that you're giving, that you have them nice and labeled because the court is going to appreciate that you're taking your time and coming in there with actual pieces of evidence that are organized and not just this big pile of papers. Lastly, make sure that if you're going to have statements from somebody else, say there are text messages between somebody else besides a party to the actual lawsuit, have them there with you if they witnessed anything, any conversations or anything like that. Those are just your basic tips for courtroom composure. Thank you for joining me. I really appreciate it. Comment below if you think that he should have been on the hook for the bedroom furniture, or whether or not she should have gotten a judgment for the money for the tattoo. Remember to like, subscribe, and follow. Go to the description. The full video link to Judge Judy's episode or the clip is going to be there. Go follow her. Again, thanks for coming by.